First, it depends on the chapter under which you file. If you file under Chapter 11 of the Bankruptcy Code, there is the requirement that you close all of your bank accounts, and then you have to open up new bank accounts called debtor in possession accounts, and the checks have to say debtor in possession on them. And that is because each month you're going to be submitting something called a monthly operating report to the court and the Office of the United States Trustee, so that the Office of the United States Trustee can monitor your use of funds. And the reason for that is because prior to filing the bankruptcy case, you have assets and you have debts. The assets go into a bankruptcy estate when you file that petition, and the debts become claims against the assets in the bankruptcy estate. And so as a Chapter 11 debtor, you become a trustee, a quasi-trustee called the debtor in possession, over the content of that bankruptcy estate, and you have to manage it with a fiduciary responsibility. And so the Office of the US Trustee wants to be able to monitor you to make sure that you're running the estate in a responsible fashion. On the other hand, let's say you do a Chapter 7 bankruptcy or a Chapter 13 bankruptcy. Generally, you do not have to close the bank account if you don't want to. Sometimes it's a good idea, and I can only speak to the way things are here in California and more generally in the Ninth Circuit. If you bank with one of two banks, Wells Fargo or Union Bank, it's generally a good idea, at the very least, if you do a Chapter 7 bankruptcy, to drain the account. You don't have to close the account, but it's a good idea to drain the account. And the reason for that is after you file a Chapter 7 petition, those banks will freeze your account. And so the money in the account will be unavailable to you, in some cases, for as much as a couple of months. Now, the bank won't take a dime out of the account, but you won't have access to the funds. The rationale that they give is, well, we don't know if the money in this account is exempt or non-exempt. And if we give the debtor access to the funds and the Chapter 7 trustee comes to us and says, give me the money in that account, it belongs to the bankruptcy estate, we're left holding the bag. So we're keeping the account closed, or at least frozen, for the good graces of the Chapter 7 trustee. I suppose I sound like a bit of a cynic, but I don't really believe that that's what's at work here. And the reason I don't is because the other banks don't do this. And I have never had a case where a Chapter 7 trustee demanded that the bank disgorge the money that was in it. So whatever's going on behind closed doors at those two banks is something with which I'm not privy, but they will freeze those accounts if they're with either of those two banks. So if you have an account with one of those two banks and you file a Chapter 7, it's probably a good idea at the very least to drain the account and set up your automatic deposit with some other bank rather than those two banks. But in Chapter 11, yes, you must close the accounts and then open up debtor in possession accounts.